appeal in the matter of Penhallurick and MD5 Ltd?
Yes, Mr. Conway.
Well, just a brief point in timing from the outset. My Lord Justice Arnold mentioned yesterday that this appeal had been listed for a day and a half. I'm afraid both I and my learned friend were labouring under, no doubt, perhaps a misapprehension that it was listed for 2 days, which is why my learned friend took rather longer than a half day yesterday.
Okay.
So,
well, look, we don't want to put you under time pressure, all right? Let me be clear about that.
I will best endeavour, certainly, my lord. My lords, I was about to address your lordships on the first work I proposed yesterday. My lords, just before I do that, can I just first pick up briefly on some of the correspondence relating to the disclosure which I mentioned towards the close of my submissions yesterday.
Certainly.
I hope your lordships should have received a clip of 3 letters.
We've got some electronic copies, but
I've got some hard copies.
I think that would be of assistance.
Yes. I think, as my learned friend and his wife, they're all...
Yes, I would say it would be somewhat bemused to get this at this stage of the litigation. And I'm in some difficulty about it because I, of course, wasn't counsel at the time. And the 2 solicitors from my firm, Instructor Solicitors firm, have both left who are dealing with it. So we're a bit of a disadvantage dealing with this. But I think I can probably make some submissions about it in an event.
All right, well, let's see how we go. And obviously, we understand your difficulties. It may be that the correspondence speaks for itself. Let's have a look.
It's slightly surprising, given that this has been a central part of the appeal since, well, a central part of the case, and it's been in my skeleton argument on the appeal since back in April, and it's only raised at this stage. So.
Well, we'll go through the correspondence. The point of this really is actually just to address when certain documents came in, rather than anything specific to the disclosure itself. But your lordships will see that there are 2 clips that your lordships now have in hard copy. One is 3 letters relating to this material. The other is actually an addendum to the claimant skeleton for trial. So probably ought to have been in the bundles alongside that skeleton in any case, but it's included here because it's just referred to in one of the letters. So can I just start with the letter from the defendant solicitors on the 12th of June, which is the first page of the correspondence clip. So this was at a point after we'd received the source code files, but before we'd received the separate metadata in the spreadsheets. And if your lordships just go to the bottom of the second page, under the heading Your Client's Disclosure Items, and items 103 to 104, you see the point made here is that the files disclosed is the source code are missing original timestamps. All the timestamps last modified on the 9th of June, which is obviously the date they were uploaded to the sharing platform. However, and then it's pointed out that Mr. Penhallurick's evidence was that timestamps on some of the VFC files had become all skewed, which rather suggests he has files relating to that source code, albeit misleading. And the letter also identifies other types of files that one would expect to see associated with the source code. And then in the final paragraph, please confirm if your client will disclose copies of any and all VFC project files in his possession, including the original timestamp files to which he's referred in his evidence. And then it goes on to deal with some proposals on the disclosure of that. And then the next letter is on the 16th of June from Mr. Penhallurick's solicitors, starts on page 4. And if you do actually go to page 5 on the clip is where this point is addressed. So in the first paragraph, it refers to the source code as text files. They contain the primary source code, and what your clients ask for are files which are only temporary, they're discarded and recreated every time we compile the program. As such, entirely volatile, unreliable as their timestamps. Key documents for the disclosure of the source code, not really addressing the fact that we'd identified there weren't any timestamps associated with the source code itself. But then they go on and saying that for the benefit of our client's legal team, our client created these forensic logical evidence files which were disclosed in January but withheld on grounds of privilege, and then a further document labelled VFC metadata from source code files. And that is what has now been provided in response to our letter of the 12th of June, that latter document. And then it goes on to explain that they were created from files of an old hard drive, which was searched. And that reflects the evidence of Mr. Penhallurick in his fifth witness statement that your lordships have seen. So that is, so we asked for the VFC files, and so what we got with those spreadsheets, and as your lordship saw yesterday, Mr. Clark noted in his evidence that they were provided in the form that he couldn't sort of independently verify them. What he did do then was attempt to match the spreadsheet files with the disclosed source code using MD5 hash values where available, or file size, and your lordship saw some of my learned friend took you to some of the evidence of Mr. Clark on that yesterday. But important to remember that he was just basing that on taking the contents of the spreadsheets, the metadata from source code files.
To be sure, but does the next letter answer my Lord Justice Floyd's question yesterday?
No, it's fair to say it doesn't. I just wanted to show that we'd asked originally, then we got these.
Can I be clear then? As I understand it, in summary, what you are demonstrating is that the original disclosure was of source code without timestamps, putting it simply. You asked for timestamps. And what you were given was the documents containing extracts of the metadata derived from the old hard drive. Yes. And the point has been made, and very fairly made, so it seems to me at the moment, that although you were given the extracts of the metadata, you weren't given the underlying files which had been searched as described in the Virtuoso letter. But then the question my Lord Justice Floyd asked yesterday is, well, when you got this letter, did you ask for disclosure of the underlying files?
And my Lord, the answer is it appears not. We attempted to deal with what we got, making the comments, as Mr. Clark did, that, well, he couldn't verify them, he was just going to deal with them at face value, as he did. But I just wanted to show your lordships that the final point to note is that on the 24th of June we received an update to the bundles in which was added item 104, which was all of the source code, some of which your lordships have seen. That's the extracts in tab 1 of the supplementary bundle. And it was only in that bundle, as I mentioned yesterday, that we saw the source code in the forms that your lordships now see it, with the some of the information, the timestamps added in at the top. And so just to note that the covering email I've included, but it's not very informative because it doesn't mention any of that. It was just given to us. But
sorry, that's the 25th of June.
Yes, that's the 25th of June. Sorry, that's on page 6 of this clip.
Yep.
I think it's a very unfair characterisation of that email. I mean, paragraph 1 says exactly what's been added. It's the item numbers to identify what it is. At the very top it says item 104. So that's the only thing that's been added according to this email. Not all the other material, like the dates created, the dates last written, or the hash value. And there's, if you look at the page, there's other bits of red within the source code. So the fact something's in red doesn't mean to say it's been added. As I say, if you look in the source code itself, there's an equals sign and a couple of commas or hyphens or whatever, which are also in red. So, and those clearly wouldn't have been added by this. So the mere fact it's in red doesn't mean it's added. The only thing this email says has been added is the reference to item 104, so that someone looking at it knows exactly what this document is. The rest of this, I tried to explain quite clearly. He obtained this data, these timestamps and the hash thing, from his forensic imaging, forensic analysis of his materials, and that's his evidence was.
Well, indeed, but I thought the point Mr. Conway was making was that this was the first time that the two things were married up.
Yes, I had anticipated he was also going to try and make the point that the dates had been added as well, but of course, as my lord said, it wasn't something which my client was cross-examined on at all. So.
Right.
Yes, just to clarify, my lords, I'm not. I'm referring. My point was that nothing is mentioned in this email about any addition to bundle I. It's not mentioned, but there were at this point additions made, and yes, my lord has the first point is that it was just marrying up some of the metadata and putting it into the source code files to enable, I suppose, bundle I to be more easily read. But there was more than that, because information was added to the source code at this point that MD5 hadn't seen at all. And that is what's referred to. Can I show you this in Lupton Fawcett's letter of the 1st of July? So this is on page 8 of this clip. And this is also the letter, by the way, in which MD5 said it wouldn't seek to rely on certain matters in Clerk 2. Your Lordships can see that in the first paragraph and the sub-paragraphs there. But then just below the paragraph, it's noted, in light of your client's skeletons, which explain your client's position and the new data added to item 104 as set out in the addendum, we're instructed our client no longer seeks to rely on those parts of Mr. Clark's second witness statement. That is because some of it is marrying up the metadata which Mr. Clark had tried to do, so we're not seeking to rely on those aspects of Clerk 2 anymore. And then the next paragraph, however, we note that some of the timestamp information added to the documents in item 104 is entirely new and hasn't been previously disclosed to our client. We reserve our client's right to challenge that information, which simply appears to have been written onto the PDF document with no apparent explanation from your client as to where the new information comes from. To help understand some of this, we prepared the attached summary of some of the metadata listings provided in your client's item 104, which highlights some of the new information we've just received from your client. And my lords, that document referred to there is actually in the bundles. That was a document that was also put in cross-examination, and that's at tab 36 of the supplementary bundle, page 632. And your Lordships will see there that the files highlighted and starred in red are noted to have been added from disclosure item 104. And I think that there's a highlight of the hashtag in relation to what is the December code. That hadn't been seen before as well. That's something that Mr. Clark had noted was missing in his evidence. So that was newly provided at this stage as well.
All right, but I note that there's no highlighting on items 1 and 2, which are the 30th of September 2006 ones.
No, although yeah, other than the hash value we hadn't seen before, so
that's
so that
not highlighted. Whereas we do see the hash value highlighted, for example, in item 3.
Which is the December.
I was looking at yes. Sorry, that was what I was referring to. That's right, my lord. But if your lordship looks at row 4, one sees the hash value there, which is identical to the September code in rows 1 and 2, and that here has a last written timestamp of the 23rd of the 1st, 2007, and that time of 4 o'clock. Now that matches the last written date and time of the file, the identical file that was found on the MD5 hard drive that Mr. Clark had referred to in Clerk 3. But it wasn't until we received this a couple of days before trial, until then, the first we'd seen of this file was on the in Clerk 3 and on the MD5 hard drive, which was just a little surprising. Just to just to show you that, if I could just, if you like, make good the point that it was new. Can I just show you Mr. Clark's exhibit JC5?
Sorry, Mr. Conroy, you're setting out on an exercise to demonstrate that what was new? The hash value for rows 1 and 2 in tab 35.
Row 4 in tab 36, which, as your lordship see, has the same hash value. So it's the same file.
Yes.
As rows 1 and 2, except that in this instance, it's a different file path. And in this instance, on this file path, it has a last written date in January. So that's not something that we'd seen before.
Right.
So it was just a little surprising that we got this information at such a late stage.
So, to cut to the chase, was it put to Mr. Penhallurick in cross-examination that this demonstrated that the date of 30th of September 2006 was an artefact and that the correct date for the file was 23rd of January 2007?
Well, my lord, I put cross-examination based on the files on the MD5 hard drive, which included a copy of that, what looks to be the same file with the same date. And I'll show you, lordship, some of that
Was it put to the witness that the date of 30th of September 2006 was false?
I don't think it was put in those terms, in the sense of what was put was that his evidence was unreliable, and what was put then was that Mr. Clark's evidence that some of the files on the MD5 hard drive originating or appearing to originate in January followed a progression that Mr. Clark had described as logical for a new software development project. And also, as I'll take your lordships to, the fact that this file was last written to, but also an executable form of that file was being built and looked at this time in January.
Sorry, Mr. Conway, I appreciate you're in the process of laying out your case, and I appreciate it. I need to give you time to develop your arguments, but I'm just trying to see where all of this is going to. Because what Mr. Caddick has submitted to us is that there was evidence before the court to show that there was an early version of the VFC software, incomplete, non-functional, but it was in existence on the 30th of September 2006. Now, what is not clear to me at the moment is whether you accept that as being a correct statement of the state of the evidence, or whether it is your submission that the evidence at trial showed that that was false and there was no such thing in existence on the 30th of September 2006.
Well, my lord, I don't think the evidence went as far as the latter. And really, our position at trial was rather hampered in that what we had, as far as the evidence was concerned, as we saw it, was Mr. Clark's characterisation of some of these timestamps as potentially being unreliable. It wasn't possible because we didn't have underlying files to properly probe these things, to make such an extreme submission as that the dates that had been given to us were false. I don't think I could have possibly been in that position. But what I did.
Well, see, if they're not false, then why was the judge not required to make a finding based on the premise that the dates were accurate?
Well, I think what the judge might have found was that the dates were volatile and could be unreliable, and therefore a given date of a given file couldn't necessarily be taken at face value. So he wasn't in a position to find that those files were definitely correct or definitely false. What he did have was evidence from Mr. Penhallurick that they could be mutable, that certainly some of those files, the timestamp information had become skewed, and that there was evidence from the files on MD5's hard drive that just didn't really seem to sit very well, and I'll expand on that a little bit with your lordships, with either the chronology that is represented by these files taken at face value, or indeed Mr. Penhallurick's explanation that during January these files were just copied across and therefore required new timestamps.
All right.
And that was really the state.
I think we need to allow you to develop your submissions, and I apologise for interrupting, but as you develop your submissions, bear in mind the question that I've asked.
Understood, my lord. So I'll come on then to the first work, and my lords, the starting point for this is really exactly what my learned friend means when he talks about the first work, and that's because my learned friend wants to point to that source code from September as evidence that the first work was made before Mr. Penhallurick began his employment. In fact, even if that date was correct, the source code that he points to, we say, was clearly not the alleged first work. And well, the place to start for this is in Mr. Penhallurick's particulars of claim. So can I ask your lordships to turn to Core Tab 11, page 108. If your lordships have paragraph 8 halfway down this page, that's where the first work is introduced, created during the course of 2005-2006, and importantly, embodying the VFC methodology that he developed. And that position was reflected in Mr. Penhallurick's evidence.
Well, again, just can we be clear? Let me tell you how I understood Mr. Caddick to be putting his case, and if you understood it differently, you can tell me, which is, I didn't understand Mr. Caddick to be submitting that the 30th of September 2006 code was the first work. Rather, his case was that it was a starting point towards the first work. The first work, as I understand his case, came into existence in late December, but the work on it had started in September. That was how I understood him to put the case.
Well, my lord, I mean, that's certainly the evidence as we understand it in relation to the first work. But it then begs the question of what, if anything, was alleged to be infringed, because it was the first work that MD5 was actually alleged to infringe, not. Well, no, it was. Well, I'll show you that in the particulars of claim. So go back to tab 11.
Well, you're undoubtedly correct. There's a claim for infringement of all the works. You can see that from the scope of the injunction that's sought, but I don't think that matters for present purposes, does it? Because what we're concerned with here is who is the first owner of the copyright. And what we're particularly concerned with, so far as the first and second works is concerned, is the attack upon the judge's conclusion that they either never existed or had been abandoned. That's the focus of the argument. And so that's the relevance for the purposes of Mr. Caddick's argument of the 30th of September source code, because he says that's evidence to show that work had been started by that point in time, which was then picked up in December and resulted, he says, in the first work, and therefore the judge's conclusion that it never existed, that's certainly wrong, nor had it been abandoned.
Well, my lords, I understand that point, and the point I'm making here is that in terms of what there were then two works on my learned friend's case. One is created in December 2006, at which point Common Ground, Mr. Penhallurick, is employed, and the judge made findings on the consequences of that in terms of whether it would be created in the course of his employment.
Yep.
And my learned friend says that some of that work embodied, he says, because it was continued, the work that was created in September 2006. And the point I was trying to explore here is that since the first work was the only thing that was alleged to infringe, then
So
whatever of the September code.
I'm not sure I know where that's from. As I read paragraph 33, it's all the works. I don't want to interfere.
Yes, but just to address that, on paragraph 23 of the particulars of claim on page 110, the works are defined as the first to eighth works.
Yes.
Yeah.
So then
So he's relying on all
works that are alleged to infringe.
Yes.
Your point is that there's no claim for infringement of the source code written on the 30th of September 2006.
Indeed. So what we have is a work created in December, which is alleged to be infringed. My learned friend says, well, that contained parts of source code that was written in September, but there was no allegation of infringement in relation to the source code that was carried on over, as my learned friend says, into the December code.
You're undoubtedly correct to say that there is no clear allegation of any infringement of a distinct work created in September as opposed to December. But that's not the purpose of Mr. Caddick's reliance upon the September source code. He's relying upon that as being the part of the process of creation of the December work.
Yeah, and I understand that point, but the point I was just generally making was that what was created at that point wasn't itself subject of any claim for infringement. And we did write to Mr. Penhallurick's solicitors on a number of occasions, asking them to clarify whether the September code was said to be the first work. Clearly, as it turns out, that was not the case. But this was also mentioned in the skeleton argument for trial. And can I just show your lordships that briefly? It's just finding myself where I was in my note. Yeah, sorry, it's tab 29, page 424. And this was just highlighting the relevance of Mr. Clark in relation to what the September code actually was. So paragraph 113 on this page noted, even if the metadata disclosed by Mr. Penhallurick could be relied on, the putative code set out in this document, this is relating to the September code, little more than a shell. It's not even close to a functional program, doesn't embody any of the functionality Mr. Penhallurick identifies as being at the core of every version of VFC. And then there's an address to Mr. Clark's evidence. The blue text here, by the way, is just to highlight those parts which relate specifically to his evidence, because at this stage it wasn't clear it was going to be allowed in. But as he explains, it appears to derive from a prior published routine by Microsoft, same basic structure. Lordships have seen the evidence on that. My learned friend took you to it. It raises the real issue. There's nothing original about this document. It's either a copy of the early Microsoft code, or to the extent it differs, such differences don't extend beyond mere commonplace implementation of well-known techniques. Now, so that was a point essayed, and what's then explained is that for that reason, no doubt Mr. Penhallurick doesn't identify that document with his alleged first work, despite the repeated requests that he do so. There's no allegation of actual infringement based on this document. And that being so, questions as to subsistence and infringement in relation to this document don't appear to matter for the present case. However, they are matters that MD5 may well have wished to explore more fully, likely adduce expert evidence on, and that would have related potentially to actually what in that September code was different from the open source Microsoft version. So, had there been an allegation that code itself was subject to infringement, we said we ought to have been told, because that is something that we might have.
That's a very fair point, but I don't understand that is the case. The case is that the ultimate issue with which the judge was confronted was any of the works relied upon created during the course of employment. But in order to address that issue, the judge had to make primary findings of fact as to what was done when. And the issue we're on at the moment is what was done in September 2006. Now, I understand perfectly well that part of your case is to say, well, even if what Mr. Penhallurick says was 100% factually inaccurate, the judge was still entitled to reach the conclusion he reached about in the course of employment. But we still have to address the question of whether it's accepted or not accepted that the factual case is correct, because the judge has rejected it. And as I understand it, you're seeking to uphold the judge on that small point.
Yes, and I think the basis of the judge's rejection, which I'll come back to in the course of dealing with Mr. Penhallurick's evidence on all of this, but as your lordships have already seen, is that when it came to it at the trial, Mr. Penhallurick described what was done in September, and that was entirely consistent with Mr. Clark's evidence and with the points that are made in the letters, where we were at this point assuming that he was going to say that the September code was the first work, and he didn't. And he characterised that September code as simply the concept, and then when it came to December, he was clear that that was his first attempt at an automated code.
So could you show us the evidence you're relying on?
Yes. Lordships could pick up the supplementary bundle at tab 31, and I'll give you the page reference in just a moment. I've got it tabbed, which is probably slightly easier. Page 473. So, at around about F in the margin, and this one at page 282, that relates to the September code. That's the very first time I was working on the VFC concept as a program. Next one is in December, where I have a breakthrough, and then thank you. Was there a working version by 2006? Yes. and then, as your lordships have seen before, this one at page 288 is my first attempt at automating my manual methodology.
So just to be clear, at F, his answer is the one at page 282, that's September, is the very first time I was working on a VSC concept as a program.
Yes.
So do you accept the witness is there saying he was working on the program in September?
Yes, that's what the witness is saying.
Right.
But he characterises it as a concept, and then it's clear that when he comes to December, that's what he considers his first attempt at an automated methodology.
No, I'm sorry, that can't be right. Because the question at G is working version, so that's what the witness is answering. So he's clearly accepting that it was only in December that he got something that worked. But he can't have been saying that he'd done nothing prior to December, because he's just said at F that he was working on it as a program in September.
Oh, indeed, that's not my submission, that he's saying he'd done nothing. It's the way he characterises it as the concept, and that was consistent with the evidence that he then gave in cross-examination on page 478. If your lordships just turn on to that, I know you've seen this. Your lordship has seen this before as well. This is where he makes his reversal on what the first work actually was. No, it should be December. Around E, he makes that concession. It should be December, and then he explains. You'd earlier said that you developed software that essentially embodied VFC methodology before you even started. No, the concept of how I was doing it was in my head. Getting it to code was a little bit more problematic. I knew exactly what I wanted to do, and he does say I started in September, but he considers that to be just a concept which he describes in his head. So, and my learned friend then says,
well, he says he started it. He says coding it was a little bit more difficult. I started it. That must be coding in September. So he's saying he started coding in September. He took a break, and then he got it working in December.
Yeah. He also says at the start of that answer, getting it to work in code was a little bit more problematic.
Well, I mean that was his evidence. I mean, in my submission, he's clearly making a distinction between what was no more than the concept, and that would be consistent with Mr. Clark's characterisation as essentially not embodying any of the methodology. It was his first.
Well, I don't understand that submission, Mr. Conway, because Mr. Clark didn't say that what was produced in September was only a concept, because it manifestly was not only a concept. It was a piece of code. And Mr. Clark says the piece of code is largely based on pre-existing Microsoft routines. But Mr. Clark's evidence is quite clear that A, code existed, and B, that it was not identical to the pre-existing Microsoft. You see, it was the kind of thing that you would commonly and routinely do. So he wasn't impressed with the extent of the amendment of the pre-existing code, but nevertheless, it's evidence that some work was done. Yes?
Yes, some work was done, which he describes as the concept. And the question then is, to what extent did that feed into the later work that was in December? And the only thing that we have on that is there was the code comparison that my learned friends took you to. What we see from that is that clearly some of that code made its way into the later December code, but some of it was different. And back to the point about exactly what was new in this code that was first worked on in September, we don't have evidence as to the extent to which what was transposed and what remained constant in December was indeed the work that Mr. Penhallurick did that was new when he was exploring the concept in September. and what represented what Mr. Clark characterised as essentially just derived from the open source version. So that's why that characterisation in my submission is important. I'm not submitting that he's saying anything other than he'd had a go in September, but he clearly regards it as quite a different thing when he got to December. That is when, as he says, that was his first real go at an automated method. So, my lords, that's our position on the first work and what that work was in September. In any event, my lord, as I've foreshadowed, we do say that the judge's determination that he couldn't place reliance on the source code was supported by the evidence, and I've addressed some of the issues with that in my skeleton at paragraphs 29 through to 30. But I just wanted to enlarge on some of those points, if I may. Your lordships have the general point that couldn't be independently verified. I won't rehearse that again. And then Mr. Penhallurick's own evidence that the timestamps were unreliable. I know your lordships have seen this, but could I just remind your lordships of what he says at paragraph 41 of his witness statement in Supplementary Bundle tab 13, page 207. And if your lordships could just read from, unfortunately, and his evidence again about forensic techniques. Didn't use forensic techniques. Dates of file creation and modification are all skewed.
I beg your pardon. Which paragraphs do you want us to read?
I'm sorry, my lord. Paragraph 41, page 207.
Right, thank you.
And just from about halfway down, unfortunately, and techniques. As such, dates of file creation and modification are all skewed. And then he goes on to explain how that can happen when a file is copied and the original USB stick is long.
So what he's saying there is that the dates may be later. He's not saying, is he, that they can be falsely earlier than the truth.
Well, he doesn't say that in terms, my lord, at all. All he says in this evidence is simply...
The creation date of the file on the new device reflects when the copy occurred, not when the file was originally created. So what he's saying there is the date appears to be later than it actually is. He's not saying, is he, that the date appears to be earlier than it actually is.
Well, no, I mean, that is, he's giving an instance of how, and one can clearly see, how that can happen, that you can get a later date when you transfer. He's not specifically saying, but what is not possible to do is to get an earlier date by this process. He doesn't give evidence on that, and I know my learned friend made that point yesterday, but that's not in this evidence, and Mr. Clark doesn't give evidence specifically on that point either. And in fact, it is possible to envisage that very thing happening. For example, if one copied a file onto a computer whose clock was a different time zone, or even just had a different setting, that would result in a different
you're
date.
postulating the computer's clock is months wrong, and wrong in a way that it makes it appear that the file was created earlier than it was actually created.
Well, yeah, and I'm not...
And there's no evidence of that, is there?
Specifically, but I'm just simply saying that he doesn't specifically address that point in his evidence. And just to show you a further passage of cross-examination on this, can I show your lordships tab 31 of the supplementary bundle, page 489.
Did you say 489?
489, yeah. The passage was just from around the bottom of this page, around about G. The context here is that I've asked Mr. Penhallurick about timestamps associated with various versions of the main VFC source code files, and I've noted in the passage preceding this that they have last written dates during working hours, essentially, or many of them do. And so the point I make just below G at the bottom is that these are all what he's identified as the core code for VFC. Correct. So what this indicates is you're working on all that code at least sometime during office hours. And over the page he says yes, and that's because security was integral to the rest of the program. And that point, just to note, is I'll return to it in dealing with this notional split between the core development and security aspect. But the point I just wanted to highlight here is he then goes on to make the point that some of these dates represent files, instances where he's copied files from one medium to another, and so he highlights November 2009 date. Others, however, have remained intact. And then around about C, he goes on to explain, I've taken it home, I've worked on it, changed the folder name. When I've copied it back into the office the next day, the folder created has changed. I may have left many copies on either of the systems, and this is why I made the reference in my statement. It's difficult to assert accuracy for all of them. However, some of them are valid. And then I go on to mention the creative date that can change. And so, well, really,
right, but where in that passage is there anything to suggest that an apparent date can be false in the sense that it appears to be earlier in time than the true date?
Well, no, my lord. And all I'm pointing out is that we were dealing with these timestamps without any benefit of expert evidence. All Mr. Clark had said is that, well, at least if you look at the last written, that's
The
pretty
general
reliable.
tenor of this is that, on the whole, the witness is saying that the timestamps can be relied upon. He accepts that sometimes where things have been copied, the date is later because of the process of copying. But when you look at what it says at F, you know, he says, he refers to the 9 o'clock. It says he indicates to him that he was working on my home at 9 o'clock at night. So the thrust of it, isn't it, is that generally these timestamps are reliable.
Well, I think the thrust of it is that some of them are reliable,
Yes.
some of them aren't.
Okay, fair enough.
And that's rather the point. And I appreciate my lords have heard from my learned friend on last written dates and what happens there, and there is an element of common sense to that, and I understand that. But the point I'm making is that all of the explicit evidence addressing this was that there could be reliability issues with these timestamps. They could become skewed, and Mr. Penhallurick had said, well, some of them certainly are skewed, and here he's saying again, some of them can't be relied on, but some of them can. And so, my lords, the simple submission is that without, particularly without independent expert evidence to actually go through these and say, well, that clearly is something that can be relied on, and that's not. The judge was in a rather difficult position in picking through which ones could be relied on, save for, as my learned friend wants, to accept those that Mr. Penhallurick said were valid, as he describes them here, and to reject those that he says were not valid or not reflective of when work was being done, based on Mr. Penhallurick's own explanation for that. So I'm merely highlighting that what we say that was a difficulty that the judge faced. My lords, the second point on this data, and I'm taking this now slightly out of the order that I dealt with them in my skeleton, but This is the files identified on the MD5 hard drive, and these, as I've foreshadowed, matched some of the files that Mr. Penhallurick's disclosure indicated have been last modified in September or December 2006, except some of them had a date dating from 18th of January onwards. And the explanation for that was, from Mr. Penhallurick, was that he had simply copied files over from his home computer onto MD5 system in January. Now, of course, merely copying to the new system is not going to give you a new last written date. One would have to at least have opened the file and saved it to create a new write to the file.
But maybe he did that.
And his explanation was that he'd, yes, in relation, but one would have to do that, one would think, in relation to each individual file. And his explanation was that when he copied the files to a new drive, he might have used the save all function, and that could result in a different last modified date without having to actually go and look at each of the individual files and save them separately. So that was his evidence. The reference to that is Supplementary Bundle tab 31/502. I wasn't proposing to go to it. That was his explanation, and that was an explanation that he gave in cross-examination for the first time. It's not something that I was particularly in a position to say whether that sounded reasonable or not, but that was his explanation.
So, what's your submission?
Well, my submission is that it wasn't, if true, it wasn't a very satisfactory answer for some of the dates on the MD5 computer, and there were two reasons for that. Firstly, the project files found on the MD5 hard drive didn't all have the same date or even one or two dates, which is perhaps what one might expect if that process of just transferring a load of ready-built code had been transferred and then saved. In fact, the last written dates were spread out over several days, and Mr. Clark's evidence was that they reflected a sort of logical progression of adding particular files in an order that would reflect what he said one would expect of a software development project. And can I just show you Mr. Clark's evidence on that? It's in Clark 3, in Supplementary Bundle tab 25, page 350.
So can I just understand, I may have misunderstood Mr. Penhallurick's evidence, but I thought the purpose, he said, of copying the file across was to facilitate development of the project. And if so, would that not be consistent with some of those files being opened and perhaps modified? Have I misunderstood your point?
No, my lady, I don't think there's a misunderstanding. I think the point that I'm making based on Mr. Clark's evidence is that it's rather, if all of these files have already been built and the software is already there, but one wants to transfer them over, it just seemed rather surprising that we had what looked like a sequential addition of files over the course of a few days. I'll just show you Mr. Clark's evidence on it, just so you have it. Tab 25 of the supplementary bundle, which the one.
So what
page 350.
350.
Yeah.
Thank you.
So just starting, picking up at the top, he explains that the four apparently oldest source code files were all recorded as the same last written date on the 18th of January at that time, and just skipping down to 35A, he notes that's because they appear to him to be the files that are automatically generated by the software development wizard. And then he describes further project files being added over the next few days, including at C, the build log.hdm on the 22nd of January, and you see at 35D, he records that attempted compilation appears to have failed because of an error that he notes. And then at F, about halfway down, just above 35, he notes that a VFC executable file was successfully created and last written to on the 23rd of January. And then the actual primary source code file has a last written date of the 23rd of January 2007, which is also the date that we then later saw in Mr. Penhallurick's disclosure. And just turning over the page, his conclusions from that at paragraphs 36 and 37, that taking it all together, and if he takes those timestamps at face value, that suggests the project created on the 18th of the 1st, developed until the 23rd of the 1st, at which point it was capable of the basic drive and enumeration in that software, or 23rd, and that's, as he explains, because he sees the files with the oldest last written timestamp were those previously created by the wizard, which he would expect to be retained in subsequent timestamps.
But I don't understand where this takes us, because I don't understand there to be any dispute that Mr. Penhallurick was working on the code in January. This evidence is entirely consistent with what seems to be common ground. So where does it take us?
Well, my lord, I suppose the point that Mr. Clark was making is that it seems if the January code was built and was all there at this point, but it's being transferred to MD5 systems to facilitate further work, one would perhaps expect that to be then result in the same date, because that would be when it would all be transferred over. Whereas Mr. Clark is what Mr. Clark...
I'm sorry, I'm struggling to understand, Mr. Conway, and I'm sure it's my fault. It's not your submission that nothing was done prior to the 18th of January, is it? You accept that work was done in December, yes?
I accept that's what Mr. Penhallurick's evidence was.
Ah, well, enlighten me then. Is it your case that Mr. Penhallurick actually started work on the 18th of January?
Well, my lord, I don't think...
And how does that square with the judge's finding?
No, I mean, I don't think that is my case. I'm merely...
So what is your case? When do you say Mr. Penhallurick started work?
Well, it's rather difficult to distill from any of these files when exactly that was. I mean, Mr. Penhallurick's evidence was based on the timestamps that he'd disclosed. He said he couldn't remember, and he'd found these timestamps, and look, there's work being done in December. That's the later version of the code, and I'd started in September, and that's what he based his evidence on. And really, as far as I could go with in terms of submissions on what these timestamps show, because we were without the benefit of actually examining the files themselves and without expert evidence, is just to point out some of the perhaps surprising features of some of the disclosure, in particular this disclosure found on the MD5 hard drive, as just not really being easily explainable by an artifact resulting from simply copying over code that by this stage, on Mr. Penhallurick's evidence, was all complete onto the MD5 hard drive. So I'm not really in a position to make a submission based on this, on an interpretation of these timestamps as to when things were done. Mr. MD5's evidence, as your lordships have heard, was that they discussed the idea of creating a software version based on the fact that there was this manual methodology, and that resulted in a conversation, as Mr. Boyd says, in around January. So it would be consistent with that evidence that work gets going at around this time.
Well, I can perfectly understand a case that says there was a conversation between Mr. Boyd and Mr. Penhallurick in January, and as a result of that conversation, he started work in January. But that case would entail the proposition that his evidence about starting in September was false, and it would entail that his evidence about having a breakthrough in December was also false. Well, so far as I can see, neither of those points were put to the witness. It doesn't even seem to be clearly your case even now.
Well, no, well, and I think what it would entail is when your lordship characterised it as a falsity, it would entail the proposition that the source code metadata on which ultimately he based his evidence as to what was done when was false or inaccurate for reasons of relating to the artifacts that Mr. Penhallurick's own evidence, as we saw it at least, suggested could arise in relation to these timestamps becoming skewed.
It would also mean that the pleadings were false, wouldn't it? And I'm not sure of that, because however you characterise it, it says in the pleadings that the first work was completed during, I think it says 2005 and 2006.
Well, that's right, but my lady, I mean, the pleadings, taken at face value, are incorrect anyway, because they assert that the first work had been created by November. So that was
right.
Or certainly before employment. I should just check before I make a submission that's not supported on the pleading. I need to go back to what's said about the first work.
First work in paragraph 8.
Yes.
Yes, actually that's right.
Paragraph 9 as well, because they were made when he was acting outside the scope of his employment by somebody else. And then goes on to say that he commenced employment in paragraph 12. And then the third work is said to have been made in mid-January 2007.
Yes.
There's no allegation of a work being made in December 2006.
Yes. I think it says by January.
Yeah. So by mid-January, yeah.
But certainly the pleaded position was different to the ultimate position at trial. And
the third work has really become or rather the first and second work have really become the third work.
Yes, that would appear to be the case. Where it's ended up is that there was a work embodying the VFC methodology on Mr. Penhallurick's case that he now, I think, says was created around December, and that was what was then continued with in January. But although the pleadings perhaps characterised that as the third work, it appears to be that wouldn't be very different from what he now says with the third work, if that is the December, if that's the December work.
I'm not sure. What's your submission about all that? Is that you say that's fatal to the case that's now being run, or
Well, as the submission is the same as I'll make in relation to the evidence, which was that clearly it's changed, and so assertions were made, and I'll show you some more assertions that were made in Mr. Penhallurick's evidence that clearly are wrong, or at least are wrong on where his case ultimately came out, and we do say that was a factor that the judge ought to have in mind and did indeed have in mind when he referred to realistic concessions being made by Mr. Penhallurick. So we do say that. Now, the explanation, in fairness, that Mr. Penhallurick gave for that inconsistency was, well, I couldn't recall, and so what I've done is when I've found the source code files, that's what I've based my timeline on. I'll show your lordships that. It's something I'm coming to in the course of dealing with his evidence, but that's essentially what he said. And so then the question becomes, well, how much reliance can be placed on the timestamp data if that's what you're grounding your account of events in? So I'm not, by making a submission that it's possible that the timestamps are not correct or can't be relied on, I'm not at the same time making a submission that Mr. Penhallurick is making false assertions, at least on these points, but what he is doing is basing his evidence on data that we say was not inherently necessarily to be relied upon. Just the one further point in relation to this disclosure on the MD5's hard drive was that, as your lordships have seen from Mr. Clark's evidence, there was an attempt to work was being done effectively on the very earliest version of the source code that Mr. Penhallurick says dates from September, and indeed there was an attempt to build that code around this time in January, and that's described in Mr. Clark's evidence as you've just seen. But one can also see it in Mr. Clark's exhibit. Can I just show you that to show you what it sort of looked like? That's in the supplementary bundle, tab 35, page 621. So, my lords, on the first page, he enumerates the contents of this exhibit, and the first one is the executable version of this source code compiled on 23rd of the 1st, 2007, and when you see that on the facing page, so it has a last modified date as you see in the table, and actually your lordships can also see that last modified date in the both screenshots here. It's actually, although it's rather difficult to see, it's in the sort of internal command prompt in the black box there. So that is clearly when this was built. That's actually a file with an internal date that one can see. And then just turning over the page, the screenshots of what it actually looked like. So this is that earliest version, and so when Mr. Clark talks about enumerating physical disks, one can see that perhaps has correlation to the status of this at this point in time. The physical drive drop down there. So it just seemed rather surprising that, given at this stage, Mr. Penhallurick's evidence is that he's already created a fully functioning version of the software in December. Why was he working on and actually compiling and seeing what it looked like, this completely basic version that he said was just the concept if it relates to the September code?
So where was it put to Mr. Penhallurick in cross-examination? The work done in January showed that his evidence about December was false.
Well, can I just show you where I put this point, and your lordships will see how it's put and as to whether it deals with your lordship's question. We'll see. But supplementary bundle tab 31 on page 503. And just at the top here, so I'm addressing him on this Mr. Clark's evidence, and I've taken him on the previous page to that. And the question here, your evidence is you've already developed much more advanced code than this by this time. Yes. So why would you have been interested in working with this much more basic version? That doesn't make sense. He says, well, it could have been there was something left in the code that I required elsewhere. I can't recall. That seemed rather surprising if, as he says, everything in the later code was the actual functioning version and contained the earlier code in any case. But that's one suggestion. Then I go on to point out, well, you also, there's a VFC executable file as well, in its version number. We don't have that in any of the versions you disclosed to us. I'm not sure that's accepted. We thought we didn't have it at any rate. But then again, just around F, it indicates that you're interested in looking at what this executable file looked like and could achieve at this point. And he says most likely that's because I had different screens and different screen resolution in the office than I did at home. And so those were his explanations, but neither of them made much sense if he developed this later version of the code that, on his evidence, had all of the, and certainly more, actual functional code that would have been present in this earlier version. And if you're interested in looking at what a different screen resolution would look like, well, surely you'd want to be doing that on the more up-to-date version. So, to answer your lordship's question, I've clearly not put bluntly to Mr. Penhallurick, this shows that what you say about the earlier source code is just wrong, doesn't it? And I'm afraid, my lord, I was rather it would have amounted to an allegation to a witness that he was, or at least as it appears to me, it would be amounted to an allegation that he was just essentially making untruths. And I didn't think that there was, I certainly didn't think there was sufficient evidence to do that. My point really was that his evidence, as I saw it at least, was that generally all of these timestamps had been skewed. And the way I saw it, and I suppose the basis on which I was putting these questions to him, was that you say they're skewed, and certainly these are rather surprising results, aren't they, if they were all to be taken at face value.
But
so
the
that's
one
the
thing that was never put, as I understand it, and you'll correct me if I got the wrong end of the stick, it was never suggested that the dates could be an artifact to the extent that an apparent date of, let us say, 30th September 2006 was actually a date much later in time. All the discrepancies that are put are all about things being later than they actually were. Nothing you've identified so far goes anywhere near to showing that the true dates were later.
I think that's probably right, my lord. I'll just, there's one more point I just wanted to take your lordships to. I'm not quite sure it hits that point squarely as such, but I did just want to draw it to your lordship's attention. And this is the issue I've also noted in my skeleton, that just some of the timestamps at least just couldn't be explained by a process of copying and saving, as Mr. Penhallurick had explained, at all. And to see this, the best place to start is the table in Mr. Clark's third witness statement, in tab 25, the supplementary number, page 351. So if your lordships have that, this is a table of certain VFC project files that were identified on the MD5 hard drive, and corresponding files from Mr. Penhallurick's disclosure. And the rightmost column shows the last written date on the MD5 hard drive, and the third column from the left, the last written date as it appeared in Mr. Penhallurick's disclosure. And then the hash value in the second column shows that these are the same file. The entries of interest on this point are the 4th and 6th rows at vfc.rc2 and vfc.ico. And if one reads across, one can see that although the last modified dates are different, at the time last written is exactly the same. And I should note, because it's relevant to the cross-examination on this, which I'll show you shortly, that Mr. Penhallurick's own exhibit showed the same phenomenon in relation to one of these files, the vfc.rc2 file, which also had the same, several entries for which also had the same January timestamp. I can just show you that in...
Sorry, with apology, the CSC last written, you say that's how it appeared on Mr. Penhallurick's?
No, sorry, my lady, the right-hand column is how it appeared on the MD5. So the CSC refers to the client-side cache, which was where these files were found.
Okay.
You say rows 4 and 6.
Rows
You said the same time.
Yeah, so different dates at the same time.
Yeah, 11:34:30.
Yeah.
Yeah.
And one can see that the further instances of the RC2 file that were in Mr. Penhallurick's disclosure in that hand-up that I took your lordships to earlier. So at tab 36 of the supplementary bundle, page 632. And looking now at the second part of this document under the heading vfc.rc2 file. So one can see again that the first 2 rows have that December date and the same time, 11:34:30, and then all of the subsequent rows have a date of the 18th of January, 11:34:30, and that recurs in all of the subsequent VFC project development files. So you've got version 1.04, 1.01, 1.03. That then remains consistent throughout. So those are the timestamps, and it was, again, not having any sort of expert evidence on this, we just didn't really understand how it was possible to end up with a different date but exactly the same time if this could occur from just kind of copying and saving a file to a new destination. So I asked Mr. Penhallurick in cross-examination just to explain that. And if I could just show you, lordships, that at tab 31 of the supplementary bundle, page 516, where it starts. So I'm just getting there. So if one looks around D, I'm showing him that exhibit that I've just taken the lordships to, and at D I say we've got a list here, all copies of the same identical file, yes, or the same hash, correct, and we see and I point out that the rows down to 6 are the same, but they don't have the MD5 hash, and then the last written date, exactly the same date and time. That's not surprising if the file was being copied to different destinations. Yes, and then I point out the 2 rows, top 2 rows, and the point about having the different date, but exactly the same time. I make a mistake about millisecond rather than to the second, which he corrects. And so I just ask him to explain. My presumption was you can't do that by just copying and saving, because you would have had to have done that on the later date at precisely the same hour, minute, second. And then if your lordships could just read his explanation from that, from H, and perhaps if I could just ask your lordships to read down to about F on the following page. So his explanation was indeed that they might have been copied at exactly the same time. I mean, 86,400 seconds in a day. That was his explanation for how that might have arisen. And in my submission, that just couldn't be a satisfactory explanation. And I think Mr. Penhallurick rather accepts that towards the end of the passage. And of course, although in fairness, I was putting to him here just the instances from his disclosure relating to the RC2 file. But of course, if looking at the files that were found on the MD5 hard drive, there was another instance of that file with the VFC.ICO. So it couldn't possibly have happened twice. So there must have been something going on here, which clearly couldn't reflect the sort of all of the natural processes of dealing with these files that Mr. Penhallurick had discussed, and he couldn't explain that. And also, again, I'm not suggesting that there may not have been an explanation, but that's the kind of thing that, in the context of this case and given its lateness and without expert evidence, just couldn't be explored properly. In my submission, it just demonstrates the difficulty that the judge was in being asked to place reliance on this material without verifiable information about this, how these had been extracted and what that process might have been, and without independent expert evidence to probe some of these issues. And that's really the point that I made about all of this disclosure to the judge in closing, which is reflected in the judgment, but just to show where I did that. I'm not going to go through all of it, but could your lordships turn to supplementary tab 32, page 599. Page 599. So it's quite a long passage of submissions where I make these points sequentially, so I'm not going to go through them all. But just from B, I make the sort of general point that Mr. Penhallurick's evidence, as he said, he fairly conceded that his recollection didn't always serve him well, but what he effectively is doing is pinning his time course on the timestamp data, and then the problem there is the issues with that data. And the first point then, I take the judge to paragraph 41 and Mr. Penhallurick's description of the timestamp data. And then from the bottom of that page and over onto around F on the following page, I just take the judge through what I've just taken your lordships to about the files on the MD5 hard drive and the logical progression, which seemed strange if that early software had been effectively superseded by much of the functional December version. And then from the bottom of that page and onto around D, on the following page, I make the point about the latest timestamps having a different date, which your lordships have just seen, and suggest that explanation just around D just wasn't plausible. And then at E on this page, the judge sort of says, well, what am I supposed to do with this effectively? Where does it take me? And I make really the submission that I've been essaying with your lordships, is that I can't, and I'm not in a position to suggest that there's any actual sort of directed tampering with this code or anything like that. And I'm not in a position to suggest that I'm not making that submission. But what it does show, and it would be consistent with Mr. Penhallurick's evidence, at least as we had understood it, is that some of this timestamp information just can't be relied upon, and that's ultimately the submission I make.
Well, yes, but you've just phrased it rather accurately. Some of the timestamp data can't be relied upon, but it's implicit in that some of it can be relied upon. So where does one draw the line?
Well, indeed, indeed, my lord, and I think what my learned friend says is that you should draw the line based on what his client says the chronology was, and you should accept his explanations aside from whatever the explanation for that last phenomenon was with the timestamps. But from the judge's point of view, he doesn't have independent evidence on any of this, and so, in my submission, he's in a rather difficult position because he knows that some of it can't be relied upon and some of it can. And he doesn't have the benefit of, I think, what would have ideally been two independent experts with able to access the underlying files to look at what the actual metadata was and to ensure that this was all verifiable. He wasn't in that position at trial, and that was part of the constraints of a 2-day IPEC trial. And as your lordship saw, he did at least invite submissions at the point where all this came in and he was considering what to do with Part 2.
Well, I'm bound to say I think this case is a classic illustration of the problems of trying to deal with fact-heavy cases under the constraints of IPEC, a problem that's been pointed out before. But anyway, that's by the by, it's water under the bridge. But so far as this appeal is concerned, I would still be grateful for clarification as to what your case is, because, as I suggested to you earlier, I can understand a case that says Mr. Penhallurick did nothing in terms of writing software prior to the 18th of January 2007, and the reason why he started work on the 18th of January 2007 was because it was following the conversation with Mr. Boyd. And his evidence that he did work prior to that is false. That would be a perfectly clear and comprehensible case. But you're not advancing that case as I understand it. And therefore, I'm still struggling to understand what your case actually is, because you seem to be accepting that he did work prior to the 18th of January 2007. So, in particular, I don't understand you to be disputing, if you are disputing it, please tell me, that he did some work in December 2006. But if he did work in December 2006, why should one not equally accept his evidence that he started in September 2006 and then took a break? So what exactly is your case as to what Mr. Penhallurick did?
Well, my lords, I think Mr. MD5's case at the trial was clearly the first of those, in the sense that its evidence was all that that there was a conversation that happened in January after Mr. Boyd and Mr. Green had their conversations about the utility of automating this software, which resulted in the development work that was then done during January. The difficulty I have there is that the judge has made a finding of fact, which was that some work was done in December. And as I understand it, the judge is there accepting Mr. Penhallurick's all evidence that he made his first attempt at an automated methodology. And so what I am effectively not challenging, and I'm addressing your lordships on the basis of, is the judge's factual finding that Mr. Penhallurick had started his automated methodology in December.
I think the judge also made a finding that the meeting was likely to have taken place in December.
He did, and I'll address your
Right.
lordships on
Thank
that, and the extent to which that was supported by the evidence. But it is my submission that I don't need that, my lady, for what I say still follows as to cause of employment.
Have you appealed the judge's finding that the meeting took place in December?
No. No, my lord. So Miles, that's the source code.
So do I understand, therefore, essentially what you accept is a skewed version of your case at trial. So your case at trial was there was a discussion in mid-January between Mr. Boyd and Mr. Penhallurick. As a result, he started work and wrote the software. And basically, the judge has accepted that case with the substitution of the date of December 06 for the date of January 07, and you defend that.
Yes, that's I think my position. My lords, I'll come on to the other attack that my learned friend launches against the judgment on the first work, which is that the judge failed to have a proper regard to Mr. Penhallurick's written evidence about when he created the software. I've touched on many aspects of this already, so hopefully I can go through it quite quickly. But the point my learned friend makes is that the judge found Mr. Penhallurick to be ultimately credible. Actually, as your lordships have seen, the judge said that he made realistic concessions during the course of what appeared to be his honest attempt to explain matters as he saw them. That, of course, doesn't mean that he was then obliged to treat everything that Mr. Penhallurick said as correct and accurate. And the problem for my learned friend is that overall, Mr. Penhallurick's evidence was anything but clear and consistent, and I've taken your lordships to some of them. A key point we rely on is what we see as the volte-face really that Mr. Penhallurick made at trial concerning the first work. Your lordships have seen that. I don't think I need to go back to the passage in question, but it was clear in my submission that this was a fundamental change in position from his evidence that he'd given quite categorically that he'd created the third work before he'd started at MD5. And actually it's so I'll come back to that point. And before then, he said he just had the concept. And it wasn't just the point about when the first work had been created that Mr. Penhallurick had to accept was wrong. He'd also given evidence that he'd been testing his VFC software on MD5's premises throughout the period November 2006 to January 2007. If I could just show you that, it's in Supplementary Bundle tab 19, page 271. Probably a bit behind the lordships. It's paragraph 5. If I could just ask your lordships to read the first two sentences.
Sorry, I got the wrong page number.
I beg your pardon, my lady. It's page 271 of the supplementary. So, the first two sentences there clearly couldn't be consistent with the evidence that he then gave in cross-examination. And he had to accept that. I think I've provided a reference to that passage at 25E of my skeleton, but actually I think it's, if I could just ask your lordships to turn it up, it's quite a short passage. It's in Supplementary Bundle, tab 31, page 481. And just from the question around about G, I put to him, and I've taken him to that evidence. You say testing software on was completed on defendant's premises from November 2006, and I take him to that part of his evidence. See that, and then he accepts, yes, I wasn't testing the software didn't exist until the end of December. Well, why did you say that you were? I apologise, that is, I was testing my software against my manual method or against the live view software. That's not what it says at all. Live view software had been introduced, and he talks about live view software, and it used his published thesis. That's some of his evidence that he came across the live view software essentially trying to perform his manual method in around December. So that was his sort of attempted explanation, but that's plainly not what his evidence was about at all. And so that was just another example of where Mr. Penhallurick had made a quite categorical assertion in his written evidence that clearly just wasn't supportable and was inconsistent with the rest of his case. And as to the sort of issue I've mentioned, that he said, well, I was relying on timestamps, but it's quite difficult to understand here in particular because this evidence in his fourth witness statement was served in June. And in fact, the same goes for his second witness statement, where your lordships have seen his evidence about when the third work was created. That was served in March, but Mr. Penhallurick's, although we didn't see it until much later, Mr. Penhallurick had identified those files, as I understand it from his evidence, back in January when the disclosure process happened. So understandable that memory can fail, but quite hard to understand why he's making these statements at this stage. But as I've said, his explanation in other passages was that he couldn't really recall when versions of the source code were created, and he'd relied on the timestamp data. And I won't go back to that, but just for your lordship's note where he gave that evidence, it's in the supplementary bundle tab 31, page 479. We do say, in contrast to that, Mr. Green and Mr. Boyd were clear actually as to their recollection of events. The judge summarises their evidence at paragraphs 49 to 51 of the judgment. Your lordships have been there, I know, but can we just have? Can I just ask your lordships to have a look at that? It's core tab 8, page 87. So the evidence is summarised in paragraphs 49 through to 51. My learned friend's taken you to this, but he records that the judge records that both Mr. Green and Mr. Boyd gave evidence that on seeing the manual method, they thought it would be useful to use software to speed up the process. Mr. Green says that in paragraph 50. Mr. Penhallurick expressed confidence that he can convert it to a program. And then Mr. Boyd's evidence was similar. He also thought it would be helpful to have software, and indeed discussed with Mr. Green the idea of hiring a third party to do the work, but Mr. Penhallurick could ensure he could do it.
So a key difference between the witnesses is not really as to timing, it is as to the fundamental question of whose idea it was to create software to do this at all. Because as this summary shows, it was Mr. Green's, Mr. Boyd's evidence, it was their idea that this should be done. Whereas, of course, was Mr. Penhallurick's evidence that it was his idea to write software. Now, that's a pretty fundamental conflict of evidence. Where's the judge really resolve that conflict, and on what basis does he resolve it?
Well, to answer the first question, my lord, I think the judge resolves this point at paragraph 54 of the judgment, where he says ultimately that he found the evidence of Mr. Green and Mr. Boyd more convincing than Mr. Penhallurick, believes they suggested to him that software should be written to automate the VFC method, and that Mr. Penhallurick...
Yes, but you see,
volunteered to
that's
do it.
predicated on the following sentence, isn't it? It may be that Mr. Penhallurick had done something by way of working on VFC software. But of course, if he had, then it can't have been the case that they suggested it.
Well,
Well, I suppose they could both have the
yes.
idea.
Well, yes,
More than one
right.
person can have a good idea.
True.
Yes, my lord, and I suppose if he'd had the idea but then hadn't done anything further, perhaps had dropped the idea, the judge, I think, would be consistent with what the judge says here. And then, of course, he comes to MD5, he introduces the manual methodology, it's welcomed, it's a useful product, and he is using it, his colleagues are using it, and it's only after that point that he appears on his evidence even, returns to it, and embarks on what he then describes in December, and embarks on what he describes as the first attempt, albeit with the caveats that we've seen and discussed, and that wasn't his absolute first attempt. So, in my submission, it would be consistent with the judge's position that, if you like, this was that would be better characterised as a sort of Phoenix project, which had been initiated but not pursued, and it was reinitiated at the instigation of Mr. Green and Mr. Boyd in the context of wanting to automate and develop a very useful tool. And in the judge's overall assessment, in my submission, the evidence of both Mr. Green and Mr. Boyd on this point, I know my learned friend raised the issue of Mr. Green's recollection as to the timings of when this happened in cross-examination. In terms of the sort of essential facts of what was going on and the conversation that happened, they were consistent in both their written and their oral evidence. And so the judge would have had that in mind, and also the flip-flopping that we've seen in Mr. Penhallurick's evidence, and the fact that he was prepared to make assertions in his written evidence that plainly were not supportable on the evidence and were wrong. And the fact that he conceded that his own recollection of events had proved flawed, and ultimately he was thrown back on his disclosure. Finally, on that, my lord, my learned friend criticises the judge's reliance on the appraisal, because he says, well, this is just Mr. Penhallurick's statement that he was working on it from February, so what? And I understand that point based on just what is quoted here, but there was also in evidence Mr. Boyd's comments as manager. And if I could just show you that, I think it's in. I'm sorry, I've just lost my place in my note. Yes, sorry, I apologise, my lords. It's Supplementary Bundle, tab 7, page 118. And so the first page is sorry.
Page 118.
Page 118.
We're looking at a manuscript.
Beg your pardon, lady?
We're looking at a manuscript.
Yes,
document.
yes. This is his staff appraisal from 2000.
Oh, it is your appraisal.
So page 118 is the sort of the first page, and these are Mr. Penhallurick's comments, and about halfway down one can see that the passage that the judge has quoted during February and March was given time to develop VFC. But just turning on to internal page 5, page 121. These are Mr. Boyd's comments, and I'm afraid, my lords, the typeface on the photocopies has become almost illegible. But I think I can read it, and your lordships can take it from me, and I'm sure my learned friend will stand up if I say it wrong. But at about what is the fourth paragraph down, Mr. Boyd says, from my simple request, is it possible to ... Mick has developed an innovative and world-leading forensic tool who's able to very quickly, despite the complexity of the task, put together VFC that has proved successful. So that's what Mr. Boyd says. Now, in fairness to Mr. Penhallurick, his evidence was that he hadn't been given the opportunity to review those comments. But the more general point, my lords, is that even allowing for that, the question sort of remains, why would Mr. Boyd have just fabricated this just a few months after the relevant events in question? So it's in 2007, long before any of this dispute was contemplated, at least so far as we know, and in the context of actually what are pretty glowing comments about Mr. Penhallurick as an employee. And I put that to Mr. Penhallurick in cross-examination. Perhaps it's just worth going to that. Actually, I don't want to leave this point hanging. It's at tab 31 of the supplementary bundle on page 494. So just at around F, I've taken him through his comments on the appraisal, and then I ask him if he's seen it, and he says, "Oh yes, this is where Jeff alludes to the VFC code being his idea." And what I put to him that passage at the bottom there. And put to him that it's clear that he at least regarded your work on VFC as being done in response to his request. And as I mentioned, Mr. Penhallurick says, well, I didn't know about this, and if I had been, I would have challenged it. But the point I then make is that Mr. Boyd's comments, he obviously regards you as a very valuable employee. Why would he have had any reason to make that comment? He says, I didn't see those comments. That's rather the point, though, isn't it? He doesn't claim to have come up with the idea in that way. And the question was, he wouldn't have had any reason to make that comment if he didn't believe it to be true, would he? No, in context, he was the driving force to speak to Mr. John Green to open the sales avenue for it. I don't dispute that. But of course, he maintains, he doesn't concede that it was Mr. Boyd's idea.
Well, isn't what he's saying at E? He doesn't dispute that it was Mr. Boyd's idea to sell it.
Well,
he says that was for an existing piece of code that I already had.
Yes.
So what the witness is saying is, it wasn't Mr. Boyd's idea to write it; it was Mr. Boyd's idea to sell it.
Yes, that's his evidence, of course, and that's his interpretation of this, I suppose. But that's not really what Mr. Boyd says. And I suppose the forensic question is, why would Mr. Boyd have made those comments if he didn't think that he had requested, approached Mr. Penhallurick and had requested him to carry out that development work? Mr. Boyd's comments aren't specific to and don't suggest at all that he was making a request for Mr. Penhallurick to assist in marketing existing software.
Well, except, of course, Mr. Penhallurick accepts that further work needed to be done before it could be marketed.
He does, and perhaps, my lord, there's a limit to how much you can read into a very short comment from Mr. Boyd, but we say certainly that was, and it was consistent.
Yeah, please, Mr. Conway, I'm not trying to say there's nothing in your point. There is something in your point. But the problem we have is that the witness has given an explanation. You say that can't be a complete explanation, and I understand why you make that submission. But the problem is the judge hasn't referred to any of this in the judgment. He doesn't quote Mr. Boyd's comments at all, still less the witness's explanation of them.
He doesn't. I suppose the point was he refers to the appraisal more generally, and he heard that cross-examination, and I suppose back to my point about the judge's expressions of his reasoning, he hasn't explicitly referred to it. It doesn't necessarily follow that it wasn't an aspect of that document, having heard the cross-examination on it, that wasn't in his mind, informing his overall assessment of the evidence, and certainly how the extent to which Mr. Boyd and Mr. Green's evidence was credible as to what had happened. So, my lords, the final point that my learned friends makes in relation to the first work is the copyright notices. I've addressed your lordships to an extent on this already, and I've made the point that the fact the judge didn't mention it in dealing with this, with the course of employment, doesn't mean it wasn't something he had in mind. And the second point is that, in my submission, it's not a point that assists my learned friend. I've sort of set out the reasons, and it might be worth actually having this in front of you in my skeleton at paragraph 31, which is in 4 tab 3, page 34. I'll just summarise the points from what is, I'm afraid, rather a dense paragraph. Firstly, as your lordships have seen, the copyright notices assert copyright from 2005 onwards, of course, well before Mr. Penhallurick wrote over the software. So they are, in effect, just his assertion. I mean, they are his assertion of ownership, and we accept that he always maintained that he owned this software. But insofar as actually reflecting any reality in law, if you like, they are simply his assertion. They clearly have no bearing on the reality of in that sense. The second point is the evidence of Mr. Boyd that Mr. Penhallurick was repeatedly told by MD5 to remove these notices. I've given the references in my skeleton here at 31. And it's a supplemental bundle.
Well, it's not disputed that was his evidence, but the point that's made is that there's no written record to substantiate that.
No, indeed, that's true. But Mr. Boyd was quite clear that he had repeatedly asked Mr. Penhallurick to remove it. In fact, and there was evidence of, on a different point, evidence from Mr. Green that at least he didn't really operate on the basis of sending formal emails. It's a small office, and he would sort of raise these things orally. I perhaps better find the reference to that after the adjournment. But the fact there wasn't a written record of these requests in my submission doesn't really go to anything. And it was also Mr. Boyd's evidence that Mr. Penhallurick...
Well, but it's a bit odd, isn't it? I mean, because we have a position where your client was selling this software for 10 years, bearing publicly a copyright notice in Mr. Penhallurick's name, which on their case was a false claim to copyright. And yet, apparently, all that happened was an occasional request to change it, made orally, not actioned, no sanction, nothing in writing. It's a bit odd, isn't it?
Well, my lord, I suppose it rather depends on the context of the work environment, which we don't really have any evidence on. There wasn't at this point any dispute as to, as far as we're aware, as to the ownership, ongoing dispute in the sense of the one that we are dealing with at the moment. He was obviously still a valuable employee. He was pretty much, as I understand it, solely responsible for this software.
Correct. And my friend's own case is that the November 08 agreement, as Mr. Green says, was because there were continuing disputes about the ownership.
That's probably that's a fair point, but well, in fact, can I perhaps it's best if I just show you Mr. Boyd's evidence on that in cross-examination. It's at 548 of the supplementary bundle, just to ground what we're sort of talking about. Sorry, and I think it's just actually I should have given the reference 549. I apologise, my lords. That's a bad reference.
Well, 548 does say that Mr. Boyd told Mr. Penhallurick on numerous occasions.
Yes. Sorry. It continues on. So I had in mind the following page. Apologise, my lady. So that's where he says that he would, at the top of page 548, please remove them, and then it's put to him that there's no written record of it, and he says again he spoke to Mr. Penhallurick on numerous occasions about that, and then it continues on the next page in relation to the promotional material, and then Mr. Boyd goes on to talk about this is all the material that I've disclosed over the last few months. Mr. Penhallurick had access to these promoted VFC. It was stated it was owned by MD5, and he makes the point that it's rather surprising. I suppose this is the converse of the point that my Lord Justice Arnold was putting to me, that there was also much information relating to VFC stating that it was owned by MD5 that Mr. Penhallurick didn't challenge.
Sorry, it's my fault, I'm sure, but are you saying there were copyright notices in the name of MD5 that Mr. Penhallurick didn't challenge? Where do we find those?
Yeah, I think that's the point that Mr. Boyd is making at the top here.
I'm sorry, I'm struggling. We have seen that various copyright notices for the software in the name of Mr. Penhallurick. I'm not conscious of having seen any copyright notices in the name of MD5, but are there any?
No, I think he's referring. Apologies, Mario. I think he's referring to MD5's name on that material. I think, my lords, my lady had it right that I'd given you a correct reference and I'd tabbed it up wrong. The point I really wanted to go to was the one that my lady pointed out quite rightly, where Mr. Boyd gives his evidence about the copyright notices that Mr. Penhallurick used, that he surreptitiously put them in. We warned him time and time again to remove it. We knew the software was ours, and he would remove them. He'd put them back in, and we'd ask, please remove them again. That's all at the top of page 548. So I do apologise, my lord. I sort of rather put myself off track with a bad marker. That's the point that Mr. Boyd makes about the copyright notices. And the final point on this was that Mr. Penhallurick also placed copyright notices on other software that clearly related to licensing tools that he didn't, or certainly doesn't now, assert any rights in. My learned friend took you to an exhibit on this yesterday. Can I just go back to that? It's at tab 21, page 287 of the supplementary bundle. Tab 21, 287. So this is an email in which Mr. Penhallurick is responding to a customer who's asking about renewal of his license, and he explains that he needs to run the VFC license manager program on an internet connected machine with the VFC dongle attached. This will show you the expiry of date of your dongle, and then there's a screenshot of the license manager program, and at the bottom of that screenshot we see he's also placed his copyright notice on that.
What's wrong with that?
Well, my lords, I suppose there are 2 points. One, as I understand it, he doesn't assert any copyright in the license manager, and of course this is the very functionality, on a somewhat different point, but this is the very functionality that is related to licensing to customers and ensuring security of the software that
Right.
Mr.
So
Penhallurick
this is the point here is that this is the aspect of the software which Mr. Caddick accepts was written during the course of employment.
Indeed, and as I understand it, Mr. Penhallurick accepts.
Yeah.
But that clearly wasn't in his mind in 2013 or 2012 or whenever it was that he placed this copyright notice.
Yeah.
So I suppose there are 2 ways of reading it. Either that distinction, which he now places such stress on, wasn't in his mind at this earlier point, and my submission that is the correct position. But certainly, on the alternative at least, it would suggest that his slapping a copyright notice on something wasn't really any, even in his mind, indication of what rights he actually legitimately laid claim to. And just the final point, my lords, that, and I think my learned friend took your lordships to this yesterday, so I don't need to go there. There were, as well as these copyright notices on most of the software sold, on all the software sold from 2005 onwards, there were also on the early development versions, the copyright one sees is 2007. And it wasn't just the automatically generated copyright, that there was, I think my learned friend took you to it, but there's certainly examples of this development software where he's placed his name and copyright dating from 2007. And my learned friend, I think, took you to the passage yesterday where, of cross-examination, where he accepted that the natural reading of a notice dating from 2007 is that the software was created at that time. So, if anything, looking at the earliest versions of the software, rather support MD5's case that it was written by, or at least at trial, that it was written by Mr. Penhallurick during 2007.
Well, I understand that point, but then we have the difficulty the judge found that the work
He
started
found
in
that some
2006.
work was done in, yes. I understand. That's why I said case at trial. So, whilst that I think brings me to the end of the first work, and I apologise that I'm
Can I just
going a
ask
bit
you
slower.
this, Mr. Conway? The judge expresses his conclusion in the alternative. He says either the first and second works didn't exist, or they were abandoned. Presumably by that he means they did exist. but they were abandoned. I mean, I understand your submissions about reliability of the evidence as to work having been done in September and possibly December. But if the work had been done, what was there to suggest that it had been abandoned?
Well, I suppose, my lord, the fact that nothing else appears rather difficult, because what's the basis for deciding it had been done in September? Presumably the timestamp information, and so the presumption is that one is looking at those at least, and then I suppose the fact that there is no evidence of that nature at all to suggest that there were any other further versions, and then Mr. Penhallurick's own oral evidence, as we've seen, that it was in December that I had the eureka moment, and that was what he then describes as his first attempt. So,
but he had a breakthrough that he started writing the code in September. So if one accepts that version, I find it rather difficult to see where in the evidence that we've seen there's any suggestion that he made a fresh start following the breakthrough.
I mean, I don't think that he characterises the September work as any kind of breakthrough. I think he says that was his concept.
Yeah.
Then the breakthrough, and then he characterises it as the first attempt at the automated methodology happens in December, which does rather suggest that nothing has happened during that time. So I think that's really the basis on which the judge was able to say, well, if he'd started in any seriousness in September, and he did characterise it as just having the concept, that one would have expected to see further work or further evidence of work done in the intervening period, and certainly it would be surprising for him then to characterise his first attempt at an automated methodology all the way in December.
But in your answer, I don't detect anything that suggests an abandonment. All right, you're treating the first work as September, and
no, I'm not. Well, I think the judge. At this point, in fact, just to ground it in terms of what the judge has got in mind when he talks about the first work. Go to tab 8, and it's, I think, paragraph 13 on page 82.
Yeah, it's the sentence, if any such software existed, I think it is likely he abandoned it. So the premise there is it did exist. What is the evidence of abandonment?
Well, my lords, I think simply the fact that nothing else was done. If it was a sort of viable start that was continued, why is there no suggestion or no evidence of any further work done on it? And then a sudden breakthrough in December, which he characterises in the way that he did.
Can I just be clear, the way the judge has described the first work you took as paragraph 13 is in terms of it's said to have been created before employment.
Yes.
So the judge is referring potentially, if we're on the premise we're talking about, to the work in September.
Yes, my lady. I think he is. I suppose the slight difficulty there is, first work on the pleadings, as it came out in the evidence, clearly couldn't be the work that was done.
Well, and he says in 45 that in evidence in chief, Mr. Penhallurick said in September 2006 he started to write software which embodied his method was served to automate it.
Yes.
And then in 48, he said the breakthrough came in the last weeks of December 2006. And then he refers to the first attempt, which he interprets as being contradictory.
Yes, I mean, I think the judge, trying to do the best I can with the explanation, I think what the judge is placing real weight on is Mr. Penhallurick's characterisation of the later work as his first attempt at an automated methodology, and his characterisation of whatever was done in September is just the concept. I mean, the passage of cross-examination that we saw, he does say he started, but he also
see, the problem with that is how can one say that what was done in September 2006 is just a concept, when even on Mr. Clark's evidence there was some code written then?
Well, my lord, I suppose the answer to that is that's how Mr. Penhallurick characterised it. He didn't kind of characterise it as these were my building blocks that I then developed when I came to my later version in September. He said, I'd had the concept, thought about it, and then come December, that's when I had the real breakthrough.
All right. Well, let's suppose that that's the correct interpretation of the judge's finding. So we infer that what the judge has found is that the witness had a concept in September 06, wrote nothing, and then started writing in December 06. Now, where in the analysis of course of employment does the judge take into account the fact that on that hypothesis, Mr. Penhallurick had the concept in September 06?
Well, my lords, I don't think the judge does explicitly refer to that in dealing with course of employment. I suppose at paragraph 67, which I'll come back to in more detail, he says, he makes the general comment, but not necessarily tied to December, that Mr. Penhallurick probably wrote a small part of the VFC software before he was given permission by MD5 to devote all of his time, and then he goes on to make his observations about the context.
But that can't be directed to September 06 because that's looking at already time post 6th of November.
Yes, and I think.
All right. Well,
I think
can I ask you a different question? Suppose it were the case that in September 06, Mr. Penhallurick had the concept of this software, hadn't actually coded anything at that point in time, and only coded it in December. Do you say that it is irrelevant to the analysis of course of employment that he had the concept in September.
Well, my lords, I think I don't think it can be dismissed as irrelevant, but its relevance may, depending on all of the factors as to the circumstances in which software was actually written, may have very limited relevance indeed. So if on that assumption he'd had nothing more than an idea, wouldn't this be nice to do? But then had effectively either put it to one side or certainly not taken any steps by way of developing it. And then in the context where he is employed and moreover his employer is using a forensic analysis tool, which he is also using, as are his colleagues. And in that context, his concept suddenly crystallizes, and he has the impetus to write the software. Then my submission that the fact that he'd had the concept may be of little or no relevance, certainly not.
Well, would you accept that it may depend on how one characterises the word concept? So if concept is purely the bare idea, one could have a piece of software which does this, then one could understand that might be of rather limited relevance. But if the concept extends further than that to not only say, thinking, let's have a piece of software, but the way in which the software will work is as follows. And he thinks through the methodology that will be employed in the software, but doesn't code it. Sorry, the use of the word methodology is unfortunate in this context. The approach that will be taken in the software.
Well, again, I think it's rather difficult to answer on a hypothetical, because of course one has to take in any of these questions a given factual circumstance into the balance, and so it may still be in that scenario that the ultimate driver for him to create the work in which ultimately copyright is going to vest is a driver that emerges from his course of employment, and that he's doing it with the mindset that what he is doing is something that will benefit his employer and is part of his duties as an employee. So it may very well still be that could result in the work being created in the course of employment. But I would accept that if the factors linking his actual work in developing the copyright in the software were, I suppose, more clearly tied to an earlier, more well-developed concept, and the ultimate impetus for him to do the work and create the copyright work had therefore consequently less grounding in his employment and in his duties of employment, then clearly that could result in it being done outside the scope of his employment. I'm sorry, I'm very conscious that wasn't a very clear answer, but I'm sort of trying to postulate.
Well, you're being realistic, which is appreciated.
There it is. So I was about to embark on the third to eighth works. And of course, now we are in a scenario where it is common ground that Mr. Penhallurick was employed. There is a bit of confusion as to exactly what the third work was. I don't think there's any easy way of resolving it. I think we probably have in all discussions. Certainly his pleaded case was that it was a fully automated version of VFC referred to as VFC1. That's in his particular claim, paragraph 13. And that would appear to be what the judge is referring to in paragraph 13 of the judgment. It follows. So that's, from the judge's point of view, this was something that was pleaded at least as completed in mid-January. Although
completed in mid-January, or was this the version that was actually released in March?
Well, again, my ladies, it's not quite clear. I don't think from any of the pleadings.
I don't think on the judge's finding it can be said to have been completed in January. Look at paragraph 54. Carried out the bulk of the work from January to March. So that would tend to suggest that the third work was completed in March.
No, indeed, my lord. So to be clear, I was quoting. I hope I'm quoting from my note, but from the pleadings, the particulars of the claim, paragraph 13, it's pleaded as being completed in mid-January. But it's also said that it was known as VFC1, and the slight problem there is that VFC1 was ultimately what went on sale in March, and so I think from the pleaded case, there's not really any suggestion that there's a difference. But as we know from the evidence, clearly there was quite significant development from the January version, the sort of proof of concept, as Mr. Clark characterised that in relation to
that was
December
December.
version. Sorry, that was December, yes. But my lord, there's then also from Mr. Clark's evidence, I think the next sequential file in terms of build size.
Well, let me tell you how I understand it. You can tell me if I've got it wrong. As I understand the way the case is now put, and I appreciate this is not how it's pleaded, and your point in that regard is well taken. The way it's now put, in effect, is this. The first work, which we've already had all the submissions about, was started in September 06, and the bulk of there was the breakthrough in December 06, and at that stage it worked after a fashion but wasn't fully functional. Then the third work, it is said, was what was created in the January to March timeframe. And that was both fully functional and had the additional security and licensing aspects. That is how I understand it's put.
Yes, I think that probably reflects where the evidence ultimately came out. What it means, I suppose, is that there's not really a third work as such. It's a development that took place during that period, or possibly you just have to say, ignore the pleadings. It's what sold in March. And one then has to consider the whole course of development.
To be sure. So it's sold in March, and the judge has found that the bulk of the work was done in January to March.
Yeah. I think that's the way the judge approaches it. So the judge dealt with this point in 59 through to 69 of his evidence. Your Lordships have been to a lot of this already, but it starts on page 89, tab 8 of the core bundle. And the Lordships have heard from my learned friend on his various attempts to pick holes in this passage of reasoning. I'll deal with each of them, but I just wanted to summarise the matters that the judge is relying on that can be still distilled from this passage. Firstly, as regards work done from January onwards, it was the evidence was pretty cut and dried in my submission as to whether Mr. Penhallurick was doing this in the course of his employment. The judge's findings are at 63 and then at 66. So at 63 on page 90, he says there's no doubt that while employed by MD5, he wrote the third work and compiled the fourth work. with the knowledge and encouragement of Mr. Green and Mr. Boyd, mentioned that all went well, it would be marketed, and he refers to Mr. Penhallurick's own evidence about working on it from late January to mid-March. And then at 66, again, there can be no doubt that making the VFC software was the central task for which Mr. Penhallurick was being paid from late January to March 2007. And that is supported by Mr. Penhallurick's evidence quoted in paragraph 63 here. It was also consistent with the appraisals that that I've taken your lordships to, albeit Mr. Penhallurick mentions February in that appraisal. But I think really the evidence was all one way, that at least from January 2007 onwards, Mr. Penhallurick was developing VFC with the knowledge and consent of an agreement of MD5. And my learned friend to that says, oh, well, that's all subject to this distinction between core functionality and security aspects, and that is something that Mr. Penhallurick raises in his evidence here. I'll be coming back to that point in more detail, but just to note at this stage that the judge ultimately concluded that it was unlikely that none of the core functionality of VFC was developed during the hours that he was working on this at work. That's at paragraph 90 of the core judgment of the judgment that he makes that finding. But I'll be expanding on that point in due course. The next question, then, my lords, is the point that I need to deal with on the basis of the judge's finding that some development work at least was done in December. And on this point, the place to start is paragraph 67 of the judgment, which I know we've looked at on page 91 of the core bundle. Could I just ask you, lordships, to remind yourselves of what the judge says there in the first three sentences? So the judge plainly has in mind here that having demonstrated his methodology, it was now a tool that was being used by MD5 for its forensic analysis work, and including by both Mr. Penhallurick and his colleagues. In fact, Mr. Penhallurick said he taught them how to use the method, but they found it rather slow and complicated. That, for your lordships, note is in tab 13 of the supplementary bundle, tab 204. So it was a methodology that he'd introduced, but clearly his colleagues had raised issues with it. And it was also being actively marketed by MD5 to its customers. And Mr. Boyd gives evidence on that. It may be worth just turning that up. Supplementary bundle, tab 32, paragraphs 500, page 551. And so, my lords, just towards the latter half of this page, from around F onwards, he explains that they're impressed by the step-by-step new way of demonstrating computer forensic material. More than happy to show it. And we started to market step-by-step methodology in January, December, sending out flyers because it gave us an advantage over other customers. So it was becoming a really an important product, both for Mr. Penhallurick in the sense that it's obviously a tool to use with forensic analysis work, but also that his employer was actively marketing it. And so, as the judge recognised in those circumstances, Mr. Penhallurick must have contemplated that an automated version of that would be used by MD5 and would be for its benefit. And in my submission, the judge was absolutely right to make that point. And my lords, this point is where I do say there are useful parallels with the case, the approach of the South African Court of Appeal in King and South African Weather Services. My lord, I was just going to come on to that case. It won't take me very long to go through. I'm conscious of time generally, but also the time, the 1 o'clock, and whether that would be a convenient moment.
We'll pause there and resume at 2 o'clock. How much longer do you think you will be?
My lords, I will. I think I can be done in about an hour, possibly. Probably in but an hour I think should be. Well, I think that would be my time anyway. So, I will endeavour to do that.
All right.